Good morning to all. So in this session, we are going to discuss about the Radiation Protection Rule 1971 under the Safety Health Environment legislation part. So what exactly this Radiation Protection Rule is? So with reference to the Atomic Energy Act 1962 and section 32, it is decided that we have to make the rules related radiation protection. So what exactly the rules are? These rules are published from 1971 with reference to section 30 Atomic Energy Act 1963, and the rule number 1 is related to the short title, which I have already told you, Radiation Protection Rule 1971. They extend to the whole of India and they shall come into force on the date of their publication. The rule number 2 is regarding the different definitions or the terminologies which are involved under this rule. Act. Now, Act means for this rule is Atomic Energy Act 1962. Then adequate protection. So it is a sufficient protection or the specific method to protect the people from the radiation hazard. So that is called as adequate protection. Then appropriate. Appropriate means whatever the suggestions, terminology or guidance given by the competent authority, that word is called as appropriate, because the other person may give the suggestions but that may not be valid in some of the cases. But if the suggestions, the guidance is given by the competent authority, then that appropriate word is used in this radiation protection rule. Then what is competent authority? Means any officer or authority appointed by the central government. So he is the main person who is going to guide regarding how to protect from the radiation, how to avoid the contaminations, and how to do the various activity which are related to the radiations. So the expert of this field is competent authority. Then contamination means the presence of radioactivity in quantities that may be specified in as excessive by the competent authority. So if there is excess amount of radiations in that working environment, in that activity, and if they may harm to the people or to the surrounding environment, then it is called as contamination. So contamination may be on the hairs of the body, contamination may be on the collars of the shirts, that may be on the shoes, etc. So if some excess, that is beyond the permissible limits by this Environment Protection Act, if that radiation is or that quantity is available on a specific part, and if that radiation may hazard to the people, then it is called as contamination. Then employer, we already know about this employer, but now it is related to the radiation workers. Now these workers are not a general worker, not a common workers. These are the radiation workers. Means these workers are doing the activities related to the radiation only. Then handle means to handling that radiation activity, that may be a manufacturing process. In some of the cases, that may be a storing activity, that may be application, that may be a transfer of that source from one point to another point or from one state to another state, and likewise. So that may be a transportation, that may be a storage, that may be a processing or manufacturing. Wherever you are going to use these radiation sources, that is called as handle in this rule. Then operational limits means the limits on levels of the radiation or on levels of contaminations. So we have already discussed about the maximum permissible limits or permissible exposure limit. So these limits are nothing but the operational limits. means within this limit only you have to operate, you have to do these handling activities, that may be storage, manufacturing, processing, etc. So all these activities are having certain limits, so that is called as operational limits. Then person, so the person mainly the radiation worker, then the person may be a partner in that activity, that may be a individual, that may be a associate, that may be a corporate people, that may be a public institutional peoples, that may be a government agency, that may be any state or any political or subdivisional thereof. So the persons, that is the people who are involved in the radiation activity, or for handling these types of activity, or for the inspection, for the auditing purpose, for any type of purpose, if these peoples are involved in that activity, then it is called as person in this rule. So that may be a legal successor or representative and agent of each of the foregoing. So that may be some of the, that just like the auditor may be from the government agency, that is called as government representative. If it is from the third party, then third party representative. If it is a consultant or agent, so all these people who are directly indirectly involved in these types of activity, that is radiation activity, that is called as person. Then radiation installation means that facility for using, for handling, for manufacturing, for processing the radiations, that is called as radiation installation. So location or facility which in the opinion of the competent authority. Now radiation surveillance, so that radiation activity needs the radiation surveillance, means measures that may be specified by the competent authority to provide adequate protection either generally or in any individual case. So if that activity, if that facility, if that location requires adequate protection, then it is called as radiation surveillance. Then radiation workers, we already discussed, the person who are involved in that radiation activity is called as radiation worker. Then radiological safety officer, the person who is designated by the employer and who in the opinion of the competent authority is qualified. If that person is having a minimum qualification, minimum knowledge about these radiations, how to protect the radiation, how to handle the radiation hazards, etc., then that person can be employed as a radiological safety officer by the employer with the concern with the competent authority with reference to the rule number 13. Then sealed source means any radioactive material which for the purpose other than storage, transport or disposal is sealed in a container. So if that particular radiation source, that chemical is not going to handle at that time, if that is not going to store or transport or dispose, then that should be sealed and in a container in a prescribed manner which is given by the competent authority. So that is called as sealed source. Then source housing means shielding enclosure providing in any device containing a sealed source in order to define the useful beam and limit the radiation levels outside of the useful beams. So we have to define the useful beam, where exactly it is, and we have to also define the limits of radiation levels for this useful beam to maximum permissible leakage levels. So this leakage means radiations. Then unsealed source, so whatever the source which is not sealed, which can be used in the process, which can be used for storing activity, which can be used in the manufacturing of something else, out from these unsealed sources continuously. So that is nothing but a leakage of this radiation, and that radiations can be registered for a particular limit, but after a certain limit that is not recommended for the unsealed sources to continue that practice or the source. So that should be sealed if you are not going to handle, if you are not going to use that source for a longer time. This is intended. That is called as useful beam. So in this source housing itself, we have defined these useful beams and the limits of the radiations. Words and expressions used in these rules, not defined but defined in the act, shall have the meaning respectively assigned to them in the act. So these are the some of the terminologies or the definitions involved in the radiation protection rules 1971, and other terminologies which are related to this radiation or radiation protections are already defined in the Atomic Energy Act 1962. So for the details, if you are not knowing about these terminologies, you can refer this act. Then rule number 3 is related to the licensings. So no person can handle this radioactive material unless and until he or she has the license from the competent authority. Then rule number 4, rules not to apply in certain cases. So there are some exceptional cases where these rules are not applicable to some extent. Nothing in this rule shall apply to the import, export, transport, possession, sale or use of timepieces, watches, instruments and other such devices containing luminous compounds in which radioactive materials have been incorporated, provided, however, that the exception specified above shall not apply. So these are the some of the exceptions cases where we can use these radioactive sources on a daily basis, but with some guidelines that can be used in the watches, in different instruments, in the timepieces, etc. And these rules, radiation protection rules 1970, is not applicable for these applications. Operations involving radioactive luminous compound, such as manufacturing or refinishing of the above mentioned devices, then such devices containing radioactive luminous compound as may be specified by notification by the competent authority. So these luminous compounds can be an exceptional item where you are going to use for some of the activities that may be a manufacturing or refinishing activity. So these are some of the examples of these exceptional cases. Then rule number 5 is related to the prohibition of employment of persons below the age of 18 years. We have already known that if the age is less than 18 years, then the person or the worker is not allowed to do these radioactive activities. Then rule number 6 is related to the conditions precedent for the issue of license. So no license for handling radioactive material shall be granted unless, in the opinion of the competent authority, these are the different conditions. That is, the request for such license is for purpose envisaged by the Act. So the purpose is important, and all these purposes for which these radioactive material can be utilized and which is permitted, and the conditions are mentioned in the Atomic Energy Act 1962. The equipment, facilities, and work practices afford adequate protections. So if the purpose is satisfied with reference to this act, then the license can be given to that person, but provided all the equipment, facilities, and the work practices related to these radioactive activities must provide the adequate protection. The person in charge of the radiation worker possesses adequate qualification to direct the work. So that person should have the knowledge about what exactly the radiation is, what are the radiation sources are, how to protect these people from the contamination or from the leakages of this radiation, how to seal the radiation sources, how to use the unsealed sources for the manufacturing, storing or other activities, and in case of any radiation accident happen, then what will be the action. So all these things should be known to that person, and that is the in charge or the radiological safety officer for that plant. Then rule number 7 is related to the period of validity of a license. So normally it is for the 3 years. The license is valid for the 3 years. Then rule number 8 is related to the power to revoke or modify a license. So if competent authority consider that for the public interest, if that license is going to modify, if it is the need of that time to modify some of the conditions, then competent authority can ask the agencies to modify the license and the condition as well as the duration for the license. Then rule number 8 is related to the power to withdraw a license. So again, the competent authority has the power to withdraw a license depending on the observations, inspections, or due to illegal activities from that concerned person. So that license can be cancelled. Then 9A++ appeal, that a person or the person's license, if cancelled or the modification is not acceptable, which is given by the competent authority to that person, then that person can go for the appeal for that particular condition to the competent authority. So all these conditions can refer in the rule number 8 and 9. Then rule number 10 is related to the restrictions of the use of radioactive material. So common person can't be used these radioactive materials. So for that purpose, you have to take the license, and competent authority can give you the license or the authority for handling these types of radioactive material. So for any purpose other than the specified in the license, for in an location different from the specified in the license, in quantities exceeding those specified in the license. So the license clearly shows these restrictions, that who is going to handle or who is getting this license. So that person should or must have the observer supervision for the activities related to this radiation. Then in the license it is clearly mentioned that for this location only this license is provided, for that date and for this duration only this license is going to provide it. All the radioactive material should be in quantities which is mentioned on the license. So in the license clearly mentioned that maximum permissible quantity for handling this type of radioactive material is this much. So you have to handle this much quantity only, you can store this much quantity only. So all these conditions are given under this license. These are nothing but the restrictions on the use of radioactive material. Then offenses and penalty. In case the licensee is not going to follow the guidelines, follow the legal provisions which is decided in the Act under section 424, 25 and 26, and if all the guidelines given by the competent authority is not going to follow by the licensee, then there may be a chances of offenses or the penalty to the licensee. Then rule number 12 is a radiological safety officer. Every employer shall designate with the approval of the competent authority either himself or a person under its employ as radiological safety officer. So if you are having the license for handling the radioactive material, then the employer should employ a person as a radiological safety officer, or the employer himself acts as a radiological safety officer, but the qualification, the knowledge, and the approval from the competent authority is must, acts as a radiological safety officer. Radiological safety officer shall, in addition to the other duties that may be assigned to him by the employer, perform the duties and functions specified in the rule number 13. So this rule number 13 guidelines for this radiological safety officer is necessary other than the duties or the functions assigned by the employer. So we will look into the functions or the duties of this radiological safety officer in the next rule. So these are the duties and functions of the radiological safety officer, that is under rule 13. To take all necessary steps aim at ensuring that the operational limits are not normally exceeded. So whatever the operational limits decided by the competent authority or given on the license, that should be followed only. To instruct the radiation worker under his charge on the hazards of this radiation and on suitable safety measures and work practices aimed at minimizing the exposure to radiation and contamination. So the radiological safety officer should take care, the safety measures should be taken and in the routine practices to minimize the exposure of radiation or contaminations. So that is the main solution or remedy to avoid the radiation hazard. So minimization of the exposure and contamination. To carry out leakage tests on sealed sources as specified in rule number 34. So we have to check, the radiological safety officer must check the leakages of the radiations. If there are some leakages but within the permissible limits, then no issue. But if that leakage exceeds the permissible limits, then we have to take care about the safety measures. We have to stop that activity or we have to seal that source, that is radiological source. To regulate the safe movement of all the radioactive material, including waste containing the radioactive material within the area under his charge. We have to take care about these movements of these radioactive materials. So that may be from one department to another department or from one point to another point or from one company to another system concern company or the government company, whatever it may be. So we have to follow the guidelines given by the competent authority. Then to investigate and initiate prompt and suitable remedial measures in respect of any situation that could lead to the radiation hazards. So we have to take care about these activities. We have to conduct some investigation, inspection, supervision for knowing about the radiation materials. That may be a storing activity, that may be a manufacturing processing activity, that may be a sealing or unsealing procedure, etc. Because sometimes it unknowingly happens. Just one of the example in the Delhi University, it happens in the last year that they have given the waste to a Bangarwala with some legal provisions, that is through the tender and all the notices, etc. But in the wastage of that physics laboratory, the radioactive source is unknowingly remained in that a particular compartment or in the equipment. So the radiation from that particular equipment is continuously going outside from that equipment, and that Bangarwala and that surrounding area is infected due to these radiations. And after some time when inspection is done, then it is clear that all the skin damages and the chances of cancer to that person is due to these radioactive sources. So sometimes it happens that in the waste also that radiation accident may happen. That is why it is clearly mentioned that including waste containing radioactive materials. So we have to take care about all these activities. It may happen in the nearby industries or in the MIDCs. Then to ensure that reports on all hazardous situations, so we have to make the report, that is radiological safety officer have to make the reports on all the hazardous situations whatever he has inspected or observed under this particular location or in the facilities, so including situations of the type referred to rule 47 or as laid down in the notification issued by the competent authority regarding the operational limits. So all the operational limits given by the competent authority and the actual operational limits, whatever in the working environment, should be mentioned in that report, along with the details of any immediate remedial measures that may have been initiated or made available immediately to his employer. So whatever the remedial measures, safety measures should be taken by that radiological safety officer and the employer, that should be noted down in that report to ensure that the ultimate disposal of waste containing radioactive material is done in a manner approved by the competent authority. So we have discussed one of the example where the radiation accident is happened in the Delhi University in the due to this physics lab particular equipment or that source. So in a similar way, that should not be happen in any type of activity, and that is why all the guidelines should be followed as decided by the competent authority. Then rule number 14 is related to the action to be taken by the employer in certain cases. When an employer receives a report which made by the radiological safety officer on any hazardous situation as provided under clause F, which we have just now discussed under rule 13, you shall forthwith transmit such information to the competent authority. So the detailed information, that is the report, should be submitted to the competent authority. Then 15 is related to the radiation surveillance. So we have already discussed that whatever the radiation facilities are available or finalized by that competent authority, that needs the radiation surveillance. So the main person is again the competent authority shall notify, specify the appropriate radiation surveillance procedures, and the employer shall comply with the same. Without prejudice to the generality of the above power, such procedures may provide that in any radiation installations, the planning, design, construction, and operation of the facilities involving the use of radiation shall be done with the prior approval of and in accordance with the specification laid down by the competent authority. So whatever the radiation installations, that may be planning, that may be design, construction, operational facilities, etc. All these things are the activities and specification should be decided by the competent authority, and employer is the main responsible person who are going to comply, who are going to follow all these guidelines which is given by the competent authority. The working condition adopted and the monitoring and personal protective equipment provided shall be in accordance with the specification laid down by the competent authority. So if the person is going to handle some of the radioactive sources, some of the radioactive material, and that person is under the contamination or in the exposure of that radiation, then PPE should be provided to that employee. So that radiation workers should be protected by the employer by providing these type of PPE. So these are the specific or special PPEs for the radiation hazard. The radiation worker shall be subjected to personal monitoring procedures specified by the competent authority. So personal monitoring of that particular radiation worker should be done on a regular basis, so that in case of any health issues, health hazards is observed in the monitoring, then that person should be isolated and should be monitored on a routine basis to avoid the health hazards. The radiation worker shall be subjected to medical examination as provided in Rule 19 or Rule 20. So the medical examination is necessary or mandatory conditions as per Rule 19 and 20. The appropriate records shall be maintained on the results of any routine measurements and investigations such as radiation and radioactive level measurements, personal monitoring measurements, and medical examinations. So due to this monitoring activity, that may be a measurement of radiation, a personal monitoring, or that may be a medical examination. So all these monitoring measures can give us the idea whether all these activities are going in a within permissible limits or not. An employer shall comply with any other special or general radiation surveillance procedure that may be specified by the competent authority. Then rule number 16 is related to the prior approval of the competent authority necessary in certain cases. So if the competent authority finds something different from the regular activity or which is not accepted limits that may be observed in the medical examination or maybe in the monitoring, that may be a personal monitoring or workplace monitoring, etc. Then in certain cases the prior approval of the competent authority is necessary to restart the activity again. Then radiation symbol. So for the location for that radiation facility for the radioactive material handling place, there should be a symbol placed outside as well as in the inside of that premises. So that symbol shall be displayed in area where exposure to radiation or contamination is likely and all the containers which contain radioactive materials. So the radiation symbol is like this, like a fan and three blades having this 60-degree angle and all the details like diameter, thickness and space is given. So this radiation symbol may be having different colors, but whatever the colors radiation symbol shall be such as may be specified by the notification by the competent authority is normally in the yellow and black color. Then rule number 18 is related to the duty of the employer to maintain certain history records of radiation workers. So whatever the competent authority is going to observe, going to monitor the activities like personal monitoring, workplace monitoring, medical examination. So all these things should be rule number 18. Then rule number 19, the specific provision for the medical examination. So each and every worker should go through this medical examination at least once in a year. In case if the worker is going to complain about anything else, then he can also go through the medical examination more than once in a year. So the authority should do the examination, that is medical examination, for the X-ray examination of the chest, all general laboratory investigation such as examination of blood, then excreta, special investigations such as examination of the skin, hands, fingers, fingernails and eyes. So these are the body parts where the contamination or the radiation hazard possibility is there. So the main thing is chest due to the X-ray, then blood, excreta, then skin, hands, fingers, fingernails and eyes. So where the possibility of contamination of this radioactive material while handling, storing or processing. So all these parts should be examined by the doctors through the medical examination. Then rule number 20 is related to the power of the competent authority to modify the medical examination of the radiation workers. So the frequency and the type of examination specified in rule number 19 may be modified by the competent authority in special cases where such modification is considered by its necessary. Then rule number 21 is related to the duty of the employer to maintain the complete medical records. So whatever the medical examinations has done by the employer, so all the records, that is medical records of all the employees or radiation worker should be recorded with reference to rule number 99-20. Then rule number 22 is related to the duty of the employer to send certain records to the competent authority when asked for the relevant excerpts from the records specified in rule 15, 18 and 21. So if the competent authority is going to ask about a specific medical record of a specific radiation worker or a specific report, then you have to provide all these reports which is mentioned by the competent authority. Then rule number 23 is related to the periods of preservations of these records. So the employer have to preserve these medical examination records because competent authority can ask anytime about this medical examination record of any person or for any reports. So all such records which are mentioned above shall be preserved for 20 years. So at least for 20 years you have to preserve all these types of records. Then rule number 25 is related to the power of competent authority to give direction in certain cases. So if the competent authority wants to change some of the directions, some of the guidance after the radiation hazards or radiation accidents or radiation exposure which can be observed in the medical examination records, then the competent authority may change the directions, guidance for some of the activities or some of the equipment or for some of the radioactive sources. So that power is given to that competent authority with reference to the 25 rule. Then rule number 26 is related to the duty of the employer to give alternative work to a radiation worker. So it is the duty of the employer to give the alternative work in case if the radiation worker is discontinued or if it is going through some of the medical treatment or due to some other reasons also. If the radiation worker is not going to continue that work, then it is the duty of employer to give the alternative work to a radiation worker, because if he is not going to handle that type of activity, if the person is continuously going for the medical treatment due to the radiation hazards or by handling these types of radiation sources, then that radiation worker must have the other work rather than this radiation activity work. So that is the duty of the employer to change that activity, to change that worker, or in case of discontinuation of the any type of worker, then the alternate person should be do that work, but with the proper training and with proper knowledge. Then rule number 27 is related to the resumptions of radiation work by radiation work. So if that radiation worker is declared by the competent authority as fit to resume radiation workers, because in the 26 we have discussed about if the radiation worker is not fit to do that activity which is related to the radiations, because the medical examination or the medical record says that he is not fit to do that activity again and again. And if after some time, after medical treatment, if that radiation worker declare that I am fit, and if the competent authorities also says that he is fit to resume that duty again, then employer can permit him to resume the radiation work. Then rule number 28 is related to the competent authority to plan the work of a radiation worker in certain cases. So when a radiation worker resumes the radiation work, which is specified in rule 27, his subsequent work with radiation shall be as planned by the competent authority. So competent authority, depending on the conditions, depending on the health of that radiation worker, competent authority has the power to plan the activities for that radiation worker. Then rule number 29 is related to the general power of inspection of radiation installations. So pursuant to the section 14 or section 17 of the Atomic Energy Act 1962, any person duly authorized by the competent authority may, for purposes of the enforcement of these rules, inspect any radiation installations. So the radiation installations are nothing but the facilities, equipment, etc. So all the facilities can be inspected by the competent authority, which is given under the section 14 and 17 of the Act. Then rule number 30 is related to the inspection of the new radiation installations. So if new facility, new equipment, or the new location is going to finalize, then for that new radiation installation, inspection should be done by the competent authority. So before starting that radiation work, every new or modified radiation installation may be inspected by any person duly authorized by the competent authority, and may also be inspected at any time thereafter. So it is not the case that before starting only, even after starting, if he is having some doubt, or if he want to observe again that activity in a different view, then he can inspect that radiation installation anytime. Then rule number 31 is related to the power of the persons authorized to make the inspection. So any person duly authorized by the competent authority under section 14 and 17 of that, the purpose of the inspection may be. So we already discussed about the inspection of the radiation installations. So if the radiation installation is new one, if the radiation installation is going to modify some of the activity, or if the radiation installation is having different radioactive material, then the competent authority is going to inspect that radiation installation. Then inspect the work being conducted therein. So whatever the work, so we already maybe a storing, work may be a sealing, unsealing, manufacturing, processing, etc. So whatever that work which is involved in the radioactive material activities, that should be inspected by the competent authority. Inspect any permanently installed or movable protective devices therein. So that may be a protective shield which can be worn by the person, that may be a permanent protective shield which is fixed at that location, or some other protective devices, whatever it may be. So protective devices should be inspected by the competent authority. Then inspect any transport or conveyance carrying radioactive materials. So inspection should be done whenever you are going to transport, to move one of the radioactive material or the quantity from one point to another point. Then make such tests and measurements as may be necessary for purpose of the evaluating radiation hazards. So you can go through the test and measurement activities which is guided by the competent authority for checking or testing the radiation's limits or the operational limits, which is decided by the competent authority and which is clearly mentioned in the license. do all such things, including examination of the relevant records, as he may consider necessary for the purpose of determining the adequacy or otherwise of the methods employed and devices used therein for providing the adequate protections. So inspection may be for the radiation installation, for the activities which are conducting in that area, or for the protecting devices, that may be some fixed devices, that may be a movable devices, that may be a personal protective devices also. And for transporting activities, for movable or flexibility items, if you are going to handle or carry some of the radioactive sources, contamination, waste, etc. from one point to another point. So all these activities should be inspected by the competent authority, and that is the power of that person or the competent authority to inspect all these activity anytime. Then rule number 32 is related to the power to seal or seize radioactive material or give direction to the employer in certain cases. So we have already discussed, if you are not going to use the radioactive material for a longer time, then you must seal that radioactive material. And if you are going to use that radioactive material in a shorter time, in a shorter span, that may be for the storing, for the processing, for the manufacturing activity, then you have to unseal that radioactive material. So the activities should be guided by the competent authority, and the power can be, or the authority can be given to the employee by proper guidance or the directions. So seal any radiation installation or any transport or conveyance carrying radioactive material, or seize any radioactive materials or contaminated equipments. So whatever the conditions which is observed by the employer and the competent authority, from that condition you can decide whether the sealing of this radiation installation, or for transporting some of the material, or for the contamination, or for a radioactive waste material. So whatever the condition is there, if it is going to decide that that should be sealed, then the employer has the authority from the competent authority that he can ask a expert person to seal that radioactive material. Then indicate in writing to the employer any modification aimed to at providing adequate protection, and the employer shall comply with the same. So that radioactive symbol should be displayed on these types of sealing. Then some instructions or guidance regarding the protective equipment, regarding the safety operating procedures, etc. should be clearly indicated on the sealed material or the installation or the equipment. Then rule number 33 is related to the sealed and unsealed sources. So every employer shall maintain or cause to be maintained registers containing inter alia the following particulars in respect of radioactive materials in his charge, namely in the case of sealed sources, the shape, size, distinguishing marks, if any, of each source. So whatever we have discussed in this rule number 32, that should be recorded in rule number 33. So with reference to this 33, we have to keep record, that is the employer's responsibility to keep records of these sealed sources with shapes, size and some marks if required. The activity with the date of measurement, physical and chemical forms, and dose rates, if any, at specified distances, along with the date of measurements of the various radioactive materials. So you have to mention the date of that activity. That may be a measurement activity, that may be an inspection, observation, sealing, unsealing, physical and chemical forms, and dose rates also should be recorded, and that is the responsibility of the employer. The dates of receipts of radioactive materials should be recorded, should be preserved. The quantities of radioactive materials issued to various radiation workers along with the dates. So whatever the material which is going to handle by the radiation worker, should be recorded with quantities and dates. Location of the various radioactive materials in the working area. We have to record these locations, these installations, these equipments, these departments where these radioactive material are going to handle by the radiation workers. Details of the quantities of radioactive materials disposed of as waste. So we have to mention also about the waste, because the contamination may be there to some of the materials which is not directly a radioactive material, but in some of the cases contamination chances are there. That is why it is called as radioactive waste, and that should be disposed of with the proper guidelines only. So before disposing, we have to mention the dates and related data like quantities and where it is handled, etc., on the records. Then rule number 34 is related to the duty of the radiological safety officer to carry out certain tests. So we have already discussed about these functions or the duties of these radiological safety officers. So one of the additional activity which can carry out by this radiological safety officer is nothing but the test for leakage. So apart from the regular duties of the radiological safety officer, he can carry out the test for the leakage, because sometimes it happens that some radiation workers finding the different symptoms related to the radiation leakages. In some of the medical examination also, it finds that there may be a radiation leakage beyond the permissible limits, and sometimes it is a need of our that we should go for the radiation leakage test, and that is the duty of the radiological safety officer. Rule number 35 is related to the precautions to be taken by the radiological safety officer in case of leakage of sealed source. So with reference to this rule number 34, if the radiological safety officer conducted a leakage test and if you found some of the leakages which is beyond the permissible limits as per as the act and these rules are concerned, then the radiological safety officer's duty is to seal that source. In the event of the immediate container or bonding which forms a part of a sealed source being cracked or broken, the radiological safety seals officer shall do the following activities. Place the entire sealed source in a properly shielded leak-proof containers. So if that seal is broken or that particular container is broken or cracked, then that particular radiation source should be properly transport to the shielded leak-proof container, taking care to prevent the spread of contamination. So we have to avoid this spreading of this contamination of these radioactive sources. Take all necessary measures to safeguard the radiation workers and others involved, including immediate evacuation of all the affected areas. Then take urgent steps to clean up any contamination. Forthwith, inform the employer of the details of the incident and the remedial measures initiated, if any, for immediate onward transmission to the competent authority. So whatever the incident happened, whatever the leakage you observe, all the details with the quantities, their impacts or the adverse impact on the radiation worker or the environment, that should be clearly notified or communicated to the employer, and the further guidance is required, then you have to concern to the competent authority. So competent authority may guide you regarding this handling of this incident or accident. Then rule number 36 is related to the loss of radioactive material. So if any radioactive material is found missing, the employer shall make immediate efforts to trace it. The competent authority shall be informed immediately about this loss. So whatever the loss of this radioactive material is there, that quantity, that type of source, what is the chemical name, etc., all should be communicated to the employer. Then telegamma sources to be provided with the appropriate source housing. So all telegamma sources shall be provided with appropriate source housing. Then rule number 38 is related to the designing of electrically operated telegamma units. So these telegamma sources should be housed, and now it is electrically operated telegamma units. So that design should be in a safety manner. So all electrically operated telegamma units shall be so designed that in case of power failure, the useful beam is automatically cut off. So if these telegamma units are operated through the electrical sources, and in case of power failure, then these useful beam is automatically cut off to avoid these radiation losses in the surrounding area. Then rule number 39 is related to the electrically operated telegamma units to be provided with manually operated devices. So all electrically operated telegamma units shall be provided with independent manually operated devices for interrupting the useful beam in case of electrical systems for interruption fails. So we have already discussed that it should be automatically cut off, but if it is not the case, if it is not automatically cut off, then you can go for the manual operations. So these manual operations facilities also provided to these electrically operated telegamma units to avoid the radiation leakages. Then rule number 40 is related to the precautions to be taken by the medical institution in certain cases. So the medical examination is the main concern, and if the radiation worker finds issues related to the radiation's exposure, then that medical treatment of provided by the medical institutions, separate exclusive wards for patients so treated. So for these radiation workers, separate rooms and separate exclusive wards should be provided for the further treatment by the medical institution. Rule number 41 is related to the precautions to be taken by the radiological safety officer in the area where gamma radiography is done. So where the gamma radiations or gamma radiography is required, then in that area, radiological safety officer shall cordon off suitable areas and control entry into those areas in such a manner as to ensure adequate protections. So where this gamma radiography is going to done, that area should be protected with the help of some adequate protection. Then 42 is related to the precautions to be taken regarding a sealed source. So every sealed source used in industrial devices such as static eliminators, thickness gauges, density gauges, package monitors and level gauges shall be provided with an adequate and efficient cover plate, shutter or shield capable of being easily, securely and quickly operated in order to effectively attenuate the useful beams. So we have to take care about the different equipments or instruments which can be used in these radioactive activities. So all these precautions should be taken while handling these types of instruments or the equipments. Then rule number 43 is related to the use of fail-safe type of interlock switches. Interlock switches used in the radiation installations shall, if so specified by the competent authority, be of the fail-safe type only. So this is the rule number 34, interlock switches. Then 44 is related to the unsealed sources to be securely closed. So it is the responsibility of the radiological safety officer to observe the securely closed of that sealing of that container. Then rule number 45 is related to the precautions to be taken by the radiological safety officer where unsealed sources are handled. So when the sealed sources are there, radiological safety officer's responsibility to observe the proper sealing of that particular container. But when we are going to handle the radioactive sources in an unsealed condition, then the radiological safety officer should handle these sources as with the safe working methods should be adopted, which is guided by the competent authority. Suitable facilities are provided for minimizing the radiation levels and surface and airborne contamination. Undesirable working habits such as using mouth operated devices, working with open wounds, smoking, eating, drinking, and the applications of cosmetics are expressly forbidden. So all these wrong habits should be avoided in these types of handling of the radiation sources. Then appropriate protective clothing under normal conditions and specified clothing as and when necessary is used. So we have to use the personal protective material, that is full body apron, which is a resistance of the radioactive sources. So that apron or full body apron should be used for handling these types of radioactive sources. Then appropriate personal protective devices such as respirators, gas masks, and airline suits are provided, and they are periodically inspected for wear and tear, hygienic, and performance status and contaminations. So apart from the full body apron, that is the construction of material is the radiation resistance material. Apart from that full body PP, they can provide you the air respirators or gas masks or airlines, etc. to have a sufficient amount of oxygens for inhaling purpose. So depending on the conditions, these PPs or other PPs can be provided to the radiation workers. Then appropriate facilities for collection of waste containing radioactive materials are provided. So whatever the adequate protections and appropriate facilities which can be decided by the radiological safety officer depending on the condition should be provided to the radiation workers through the employer. Then rule number 46 is related to the ventilation system involving airborne contaminations. So there are chances of air to be contaminated. So ventilation systems or appropriate and adequate ventilation should be provided in that area. Then 47 is related to the spillage of radioactive material. So in case of spillage of this material, that may result in personal injury or surface contamination or airborne contaminations. So in that cases, if this spillages occur, radiological safety officer shall take steps to arrange for the immediate decontamination of affected person. So if this spillage of this radioactive material is infected to that person, then decontamination or immediate decontamination should be done by the officer. Take steps to prevent any further spread of contamination. So if the contamination is done, after that we have to prevent this spreading of this contamination. Then arrange for the immediate decontamination of affected areas. Then forthwith inform the employer details of the incident and remedial measures initiated, if any, for immediate onward transmission to the competent authority. So depending on the case, if it is a controllable case, if you can decontaminate the person or the area, or if you are capable to control the spread of contamination, then you have to inform only to the employer about this incident, that this thing is happened, the spillage of that material is happened, and we have controlled all these activities, we have decontaminated that person or the areas from this method, etc. And if it is not controllable, then you have to inform to the competent authority for further guidance and steps. Then rule number 48 is related to the experiments on animals. In radiation installations where sealed or unsealed sources are used in the experiments on animals, appropriate facilities should be provided. So the handling of such animals, the prevention of spread of contamination, and safe disposal of waste containing radioactive materials. So all these things should be taken care while doing the experiments on the animals. So normally we have decided the maximum permissible limit or the permissible exposure limit as per as these radiations or toxicity or some other characteristics deciding. So for these purposes, before deciding this factor, we have to conduct the different experiments. Means we are going to intentionally make or prepare exposures in that particular area, that is controlled area, and we have to put the animals in that area, and we have to observe what exactly should be the limits or the maximum limits of the exposure. And that is why this experimental part is also essential before or finalizing the permissible exposure limits in any of the rules or regulations, but we have to take care of these things. Then rule number 49 is related to the luminizing compounds. So in radiation installations where luminizing compounds containing radioactive materials are handled, appropriate facilities for ensuring radiation safety shall be provided. So for handling these types of luminizing compounds, we have to provide some protective devices. We have to provide some safe operating procedures for that persons for ensuring the radiation safety. Then rule number 50 is related to the approved procedure to be adopted for mining, processing or fabrication of radioactive material. So for all these activity, again we have to take care, we have to conduct some safety measures, we have to provide some safety guidelines which is approved by the competent authority. Then precautions to be taken in mining, processing or fabrication operations involving radioactive materials. So in some of the cases, these radioactive materials can be used for these types of operations, and before handling these types of radioactive materials, precautions should be taken, some safety measures should be taken, some safety operating procedure should be followed, and all these things can be decided and guided by the competent authority. So to check the environmental radiations, to check the leakages, to check the medical records of these workers who are going to handle this type of radioactive materials in these types of operations. All the things should be inspected or observed by the competent authority. Then 52 is related to the disposal of animal carcasses and foliage containing radioactive materials. So whatever the radioactive material used for the experimental purpose, or in some of the cases due to the incident or accident, and if the animals are infected due to this radioactive material, then that should be disposed of, which is the guidelines provided by the competent authority. Then 53 is related to the autopsies of cadavers containing radioactive materials. The performance of these autopsies on the ultimate disposal of cadavers containing radioactive material should be done only in accordance with the methods approved by the competent authority. So whatever may be the case, that may be the spillage, that may be the test, that may be the observations, that may be the disposal, that may be the experiments, that may be the different cases which is related to the radioactive material, then that should be done. That may be the controlling of spillage, that may be the controlling of spreading of the contamination, or that may be the decontamination activity, that may be the disposal activity. All these activities should be done accordance with the methods approved by the competent authority only. Then rule number 54 is related to the license for handling radioactive material. So every person's handling radioactive material shall, as required by the rule 3, obtain license from this competent authority. So we have already discussed all these three things which are mentioned in the rule 3. So the competent authority within 6 months from the date of coming in force of these rules. So person can apply for the handling of this radioactive material license, and he can get the license within 6 months if all the conditions are approved and observed and checked by the competent authority. Then rule number 55 is related to the employer to arrange monitoring of these radiation workers. So it is employer's duty to arrange these types of monitoring. So the monitoring may be the medical examination monitoring, that may be a personal monitoring of the radiation worker, that may be a workplace monitoring within that area where the radiation workers are working. So all this monitoring should be done within the 6 months from the date of coming into the force of these rules. Right? Then rule number 56 is omitted with these notifications which has referred in the 1975. So there are 56 rules in these radiation protections rules 1971. Thank you.